This is Forward Latino. We're glad to have you here. We are going to have as our discussion, Defending Democracy, a legal review of legal challenges to the 2020 election, electoral vote certification, inciting insurrection, and impeachment. Forward Latino is a nonprofit, nonpartisan advocacy and service organization dedicated to assisting Latinos pursuing the American dream. Forward Latino fulfills its mission through advocacy, civic engagement, education, and service delivery. We have members in 29 states. I'd like to also welcome, I am your National Vice President for Forward Latino. We also have Eileen Figueroa, who is our Secretary and Director, Patricio Provatina, who is our Board Member Director, Arturo Martinez from Milwaukee, and going back is Patricio is in Washington, D.C. tonight. Eileen is in Milwaukee, Wisconsin. We also like to thank our co-sponsors. Our co-sponsors are the American Constitution Society, Milwaukee Chapter, LULAC Iowa Council 307, NAACP Milwaukee Branch, and more. And now I would like to turn it over to our board members to introduce our guest speakers. Go ahead, Eileen.
Thank you, Joe. Ed Fallon is currently an associate professor of law at Marquette University Law School, where he has been a member of the faculty since 1992. His primary areas of teaching and scholarship include constitutional law, corporate law, immigration law, and white-collar crime. He also practiced law as of counsel at the Milwaukee office of Gonzalez, Saggio, Harlan, LLP, 2005 to 2013. And as an associate at the law firm of Fried, Frank, Harris, Shriver, and Jacobson, 1988 to 1992.
Dr. Martinez?
Yes, hi. Let me introduce Ann Jacobs is the chair of the Wisconsin Electric Commission. The Wisconsin Electric Commission is the organization charged with the administration and enforcement of Wisconsin election laws. Ms. Jacobs, a graduate of the University of Wisconsin Law School, began her career as a public defender and is the founder of Jacobs Injury Law SE, addressing the issues of neglect, financial abuse, fraud, medical malpractices, and more.
Patricio.
And last but not least, we have Craig Mastantuono. Craig Mastantuono is MKE Chair of the American Constitutional Society. The Society is committed to defending the Constitution and ensuring that it remains one that is of the people, by the people, and for the people. Mr. Mastantuono earned his law degree at DePaul University of Chicago and is a faculty member at Marquette University Law School. Craig is the co-founder of Mastantuono and Coffee, where he practices criminal defense and crisis.
Okay, and I'd like to now introduce our national president, Daryl Morin, who will be the moderator for tonight's event. Take it away, Daryl.
Good evening, everyone. Daryl Morin here, and thank you, Joe, and board members and everyone for coming out tonight. We find ourselves this evening in an issue that I'm sure, or in a time none of us ever expected to happen. We've seen a serious threat and attack not only on the U.S. Capitol, but on the Constitution and our democracy. And I know we've been receiving calls from people wanting to know how can they successfully advocate for justice, for the Constitution and our democracy. So I'll be helping set the context for our discussion this evening. January 6th, truly a day that will live in infamy. I know many of us have seen the footage to much dismay, where we've seen over 50 of the police officers who were defending the Capitol were wounded that day. A total of 6 individuals are now deceased because of that violent, brutal insurrection there at the U.S. Capitol. And we all watched breathless as we saw the U.S. House of Representatives and the Senate locked down and eventually rushed out. I myself If you look at that image in the middle where the Secret Service have their firearms drawn as people were trying to enter the House chamber, my son saw those images, and I'll never forget the way he said, "Dad, I'm scared." And I think he really echoed the words of not only how he felt, but all of us felt around the nation as we saw the violence that erupted following the rally, following all of the tweets and misinformation that's been spread over the last several months throughout our nation. You know, much of this has been fueled by misinformation regarding the election results. So we're going to review that just really quickly before we jump into the meat of our discussion tonight. Here are the actual tallies from the 2020 presidential election with regards to the popular vote. Nationwide, Joe Biden had over 81,000, President-elect Joe Biden, over 81 million, I should say, votes, where President Donald Trump had 74 million. President-elect Biden won by 7,059,741 votes. And as we're all aware, the president isn't selected here by the popular vote, but by the electoral vote. So when we look at that, he easily surpassed the 270 electoral votes needed to win, and he did so by a margin of 74 electoral votes. So once again, we've kept hearing this constant stream of messaging saying that there was tremendous fraud in this, and that there were a number of lawsuits where the judges, ironically, both liberal and conservative, were refusing to hear the evidence they had. We saw a number of different cases brought forth, particularly here in Wisconsin, where some of them still move forward. We heard them echoed the other night in the US Senate chamber as they were discussing the certification of this electoral college vote. So we thought it would be more than appropriate to invite the chair of the Wisconsin Election Commission, Ann Jacobs, to come in and share some of the baseless claims and complaints that were filed here, knowing that they're probably going to be representative of what we see throughout the nation. So with that, let me hand it over to you, Ann.
Thank you, Daryl, and thank you to Forward Latino for including me in tonight's presentation. I am the chair of the Wisconsin Election Commission. I am speaking tonight on my own behalf and not on behalf of the commission itself. When Daryl asked me to speak about the 2020 election challenges, the title is the Baseless Election Challenges, and pretty much that encompasses all of the election challenges that we have seen throughout the country. The genesis of this insurrection, the genesis of this attack on our Capitol, this attack on our democratic process, was allegedly that these elections had gone awry, that there were people were elected who didn't get the most votes, that things had gone wrong. And the problem is I think we're treating it as if that's actually a serious thought. And that is not a serious thought, because these elections were fair, they were public, they were counted once, twice, 3 times, and so on. And so we need to really investigate as to what sort of all these different challenges were. And I wish I could do that with you, but I have 15 minutes tonight. So we're going to sort of highlight examples of the different kinds of claims that were made so that we can understand why this is not a real issue. And what it is it's a fabrication that has generated an insurrection. So I wanted to list just a few of the cases here. I think I'm named as a party in all but one. These are the different cases that have been brought since November. There have been a lot of litigation in Wisconsin on other election things. That's normal. But in this case, these are just some of the cases that have been filed since November, all of which are trying to overturn the election. So all of these are trying to overturn the election here in Wisconsin. And what's interesting about it is none of these cases alleged fraud. They called it fraud. They used the word, but it didn't allege fraud. It did not allege that people who were not eligible to vote casted improper votes. Every single case alleged that registered voters who had the right to vote somehow should not have been allowed to cast that vote. Registered voters with the right to vote shouldn't have been allowed to vote. And that's at the crux of how undemocratic and how frightening these claims are. Next slide, please. So we have to start by pointing out that those 9 cases, or however many I have on that previous slide, every single case has either been lost or it will be mooted out. And mooting out is a legal term, and it basically means by the time they get around to deciding it, it won't be relevant anymore. And the mooting part is there were a few cases that were lingering at the US Supreme Court. The court today said, we're not going to hear them until February. Well, that's interesting because who gets inaugurated in January? Our incoming president, Joe Biden. So the fact that the Supreme Court isn't even going to hear those cases till February tells you these cases are no longer a thing. They are simply relics of this path we have been on. And I put this quote here because this is a judge appointed by Donald Trump. And this was Judge Ludwig in the Eastern District of Wisconsin talking about in his concluding remarks on a case that was brought. And it says, and it calls this an extraordinary case, and it reads, a sitting president who did not prevail in his bid for re-election has asked for federal court help in setting aside the popular vote based on disputed issues of election administration. What I was talking about, legally registered voters who wanted to vote and they want to prevent them from doing that. Issues he plainly could have raised before the vote occurred. This court has allowed the plaintiff the chance to make his case, and he has lost on the merits. In his reply brief, plaintiff, meaning Donald Trump, asks that the rule of law be followed, and it has been. Next slide, please. So there were sort of 2 themes to the litigation that we saw in Wisconsin. And by the way, this is actually true across the country. It's true in Arizona, in Pennsylvania, in Nevada, all these different states where they brought very similar complaints. So one of the themes is registered voters legally entitled to vote voted wrong procedurally in administrative ways. And the second one was we waited to sue until we lost and people weren't very nice to us about it. And that sounds a little flip, but that's a big part of the complaints in this case. So I wanted to sort of talk a little bit about, give an example of each of these because there's probably about 25 different examples under each of those 2 categories. But I wanted to give an example of how absurd some of these were. So if we could have the next slide, please. So if you've ever applied for an absentee ballot in Wisconsin in your clerk's office, you were given an envelope to complete. And it says at the top, official absentee ballot application/certification. Why is that? And that's because about 10 years ago, the Elections Commission decided it was sort of stupid to have people fill out the same piece of information twice, once on a piece of paper and once on the absentee ballot envelope. So we combined them. And this was back good 10 years ago. Saves paper, saves aggravation, and it functions the same way. You go in, you complete the top, you give it back, you get a ballot, you fill it out, you sign your certification, your ballot is in. The claim made in Wisconsin was that somehow the document that is an absentee ballot application wasn't actually an absentee ballot application, and that apparently every single person who had voted in a clerk's office for 10 years ago, for the past 10 years, has voted wrong. All those votes were incorrect. And that they were required to have a separate piece of paper for the application. Now, every court has thrown that out because it's ridiculous. Just is. The second part of which is it's also an absurd basis to disenfranchise hundreds of thousands of people. All right. So in the Milwaukee and Madison counties that were being challenged by the Trump crew, they wanted to throw out several 100,000 ballots under this theory of this being an improper application. And I want you to think about that whole gotcha idea that something we've been doing for 10 years suddenly is illegal and you've lost your right to vote. Because everything we're going to be talking about today is about losing your right to vote. People in our state, in Wisconsin, losing the right to vote. People in all the other states losing their right to vote. I've put some other examples of how people were being told that they had lost their right to vote. People who said that they were indefinitely confined because of a pandemic. They wanted to throw out everybody who said they were indefinitely confined. They didn't distinguish between anyone. So anybody who was disabled, maybe they broke their leg, they couldn't get out of the house, they wanted to be considered indefinitely confined, everybody was going to be thrown out. Again, the idea was legal voters being tossed out, their votes being tossed out.
And if I could ask a quick question.
Sure.
Was this something where it just happened because there was a Democratic governor in the office, or when did this change actually take place? And was there anything like that happening?
It occurred under the Walker administration with the Walker Department of Justice. So that was Brad Schimmel's office who approved this with the Government Accountability Board.
A Republican.
So it was really a while ago, and it has been in place since then. So this was not anything new. We've all, if you've ever voted in your clerk's office, this is how you voted.
Thank you.
Sure. So let's take a look at the next slide. So again, registered voters who have the right to vote being told they voted the wrong way. An entire lawsuit was filed on the issue that communities put out drop boxes like the one you see here for people to safely drop off their ballots. Now, remember, we're also in a pandemic. So being able to be outside and drop off your ballot safely in the slot is a terrific idea. It's safe, it's secure. Look at these giant boxes that were put out. Communities across the state did this. And in smaller communities, it was interesting. A lot of them used the same slot that you put your property taxes in when you pay your property taxes, or where you put your bills in that you pay for your community. So these are places that have been secure and safe and been used for all sorts of different functions. And an entire lawsuit was filed to say that drop boxes were somehow illegal under Wisconsin law. Another attack was the folks in Madison who went to the parks and handed their ballots to election workers, to paid election workers in the park in Madison. It was unfortunate. The Chief Justice in Wisconsin stated that they were volunteers in her opinion, and that was an error. I'm sure it was an inadvertent one. These were paid election officials who went outside to a safe place and collected ballots. They wanted all those thrown out too. Why? Registered voters legally entitled to vote who had received absentee ballots in compliance with the law. This is about disenfranchisement. Next one. This is one that was all over right-wing media, okay? This graph makes me crazy. And I want to briefly explain why, because you're going to see it everywhere. And if you go on any right-wing, Twitter, whatever, you will see this. So what happens in Wisconsin is there's two ways to count your absentee ballots: at each individual poll site or at a central location. Some communities choose one, some choose the other. City of Milwaukee chooses to do it at a central location. Now, what that means is they start counting ballots at 7 o'clock in the morning, because by state law, they may not start any sooner. They can't do anything to those ballots until 7 o'clock in the morning. They can't even open them 7 o'clock in the morning. So they started counting 169,000 ballots at 7 o'clock in the morning. Now, this may not come to anyone's big surprise, but it takes a long time to count hundreds of thousands of ballots. So what happens is Milwaukee is not allowed to report that tally until it is complete. So once they start that central count, it goes until it is done. And it was done at about 3, 4 o'clock in the morning. It gets posted to the websites as required by state law. It then gets picked up by the media groups who are all staying awake late at night. And it results in what this graph shows, which is a bump up. Of course it does. They just added 169,000 votes to the tally. And the supposed fraud, and I'm using scare quotes because it's not fraud, was that somehow Joe Biden then took the lead, which is not surprising given the demographics of Milwaukee, the polling of Milwaukee, and the expected votes. So everyone who says there was a midnight vote dump, tell them they are so wrong and that it's just a fabrication. Other examples of sort of this computer-based stuff is the idea that Dominion voting, I'm still on the previous one, Dominion voting machines were somehow corrupt. Dominions were not used in Milwaukee, Madison, or any county carried by Joe Biden. They were used in Trump counties where he won. So, I mean, if you're going to corrupt a voting machine, I don't think you did it right. Dominion has launched a very strong attack back at this because their machines were not faulty. We actually audited, as the Elections Commission, Dominion voting machines across the state. They didn't change votes. They didn't do any of that. They functioned exactly as they were supposed to. Next slide, please. We waited to sue until we lost and people weren't nice about it. Again, I realize this is maybe a little glib, but I wanted to point out that everything I've run through with you so far tonight was exactly the same in 2016 when Donald Trump won. None of this changed since 2016. And I want to point out, nobody complained about it in 2016. And I would also point out that the Democrats didn't complain about it in 2016, even though they lost. And the reason is, again, these are registered voters with the right to vote who did properly exercise the right to vote. And it is preposterous that you would go in and try to disenfranchise those people. There were a lot of complaints there was a state legislative hearing. There were a lot of complaints by people who said that when they went to go protect the vote on behalf of the Trump campaign, that the people that they were interacting with weren't nice to them. And I thought that was really such an unusual reaction. People have died for the right to vote. People have been killed. They have been attacked by dogs and fire hoses, and they have marched and they have been strung up. And the idea that the right to vote is something that one would glibly go in and try to take away from people and expect them to welcome you, I thought was sort of a really bizarre view of this. But I think it ties into what we saw at the Capitol, which is this belief, this misguided belief that they're in the right, because they're not. Every court said so, but really this belief that they were somehow in the right and therefore shocked and amazed that people were not seeing it the same way. One of the other issues was, as you can see, I put up a photo of trying to have COVID-safe observation of the recount process. You can see here, this is the city of Milwaukee. They've got tables, plexiglass, 6-foot lines, chairs, and the like. People were really trying to make this process as transparent as possible. And every time I hear a complaint that we couldn't see anything, I always want to say, what was it you were looking for? What were you looking for? What was it that you wanted to see that you couldn't see? Because the answer is usually, well, you know, we were going to see fraud. Well, what would that have looked like? Tell me more about that. Because the answer is they don't really know. They just know they were supposed to be upset about things. Next slide, please. And finally, I want to talk a little bit about latches. And if you've heard a lot about latches, this is not that kind of latches. I put the image up because that's latches with a T. We're talking about latches, L-A-C-H-E-S. It's a legal term. And basically latches says you can't sit on your rights, that you've got to be proactive about things. You can't just wait until the last minute and expect for things to go your way. So in this case, court after court after court said to the Trump campaign and the other ancillary parties who were advocating the same position, 2 minutes, that what they needed to do, they needed to have brought all of these complaints before the election. Because you can bring complaints ahead of time. You can bring matters in front of the judge. You can go in front of a judge and say, Judge, I think that application form is wrong and should not be allowed to be used. And why do we allow that to happen ahead of time? Because we can fix it ahead of time. Because the solution of disenfranchising hundreds of thousands of people isn't a solution to that problem. The solution is to do it ahead of time. And I wanted to point out one more thing, because this is an important rallying cry that you're going to hear. We were never allowed to bring forward proof. That is untrue. Absolutely. Every opportunity these folks were given to bring forward specific proof, they either didn't. In the case of the state court case of Donald Trump versus, I think it's Pence, no, actually it's Biden. There was an entire day set aside for a live hearing, and instead there was a stipulation to facts. In the Ludwig case that I started out today's presentation with, that quote from that case, Judge Ludwig's decision, they were given the opportunity and they were found deficient on the merits. That means based on the facts. So every time they had a chance to bring in facts, like show me who these fraudulent voters were, show me who these people were who were not entitled to vote. Every time they said, never mind, we don't have it. So I want to point out that that is a false claim as well. And these are what we're seeing. This is what I think was the genesis of all of this insurrection activity coming out of all these different states. And it has been amplified and lit on fire to the point where we nearly lost our democracy in one afternoon. And so I encourage all of you to push back when you see this. And the truth is out there. PolitiFact has PolitiFacted basically all of this. Go look for it. But this isn't real. And we can't be justifying anything by pretending it was real, because it wasn't. Thank you.
Wonderful. And thank you so much. It just goes to show that when you look at things in a vacuum, when you hear things without having the full context or information behind it, how dangerous these things can become. And we know that this has been just continuing on and on throughout the country. So thank you so much for enlightening us and obviously making us all better advocates, because now we know the response, we know the facts behind it. Next, we're going to go and turn it over to Craig Mastantano, and let me bring up the right slide here. Forgive me, I'm going to jump back here real quick. There we go. Okay. So Craig is once again the chair of the American Constitution Society, and also does tremendous criminal defense work here. And he's going to walk us through some of these terms we're hearing and some of the criminality, what we saw, and what does it really mean within the context of our democracy, and more importantly, the law. So with Craig, let me turn it over to you. You may have us on mute there.
So sorry. Thank you, Daryl, and thank you to Forward Latino for organizing the event. And it's wonderful to be joined by such a distinguished group for our presentation here tonight. I generally defend people accused of crime. In that regard, I work in and among and across the aisle from investigators, law enforcement officers, and prosecutors on a daily basis. And a lot of that work doesn't involve simply taking cases to trial and fighting in court as we see on TV, but also working on the same side sometimes as law enforcement officers who are working with clients of mine to produce further investigation, and also in a collaborative approach with prosecutors where we work on plea agreements and figuring out what to do about violations that have been committed. I teach criminal practice at Marquette University Law School. Much of the teaching students to engage in much of the same things that I just discussed and referenced, the prosecutors and defenders of tomorrow, if you will. So it's from that standpoint that I have had a lot of opportunity personally, of course, to think about the events at play since Wednesday in our capital of last week, and what we should expect to come down the pike, so to speak, as criminal prosecutions move forward. Next slide, please, Daryl. So, insurrection. Generally in the law, there is a tendency of prosecutors to want to go after and prosecute kind of the largest bad actor in any event or crime. And the president is potentially that person as it relates to the events of January 6th. And I've personally received a lot of questions. Well, can't we prosecute the president for the crime of inciting insurrection? And so I'll take an approach that shares my general thoughts with regard to a federal criminal prosecution. First, We should keep in mind that the District of Columbia is a federal district, and so the prosecuting authority for all crime within that federal district is the federal United States Attorney's Office, as opposed to, for example, the District Attorney of Milwaukee County, who is a state authorized official. And so all prosecutions related to the events at the Capitol would be brought by the United States Attorney's Office for the District of Columbia. When people think about whether the president incited an insurrection, you don't need a law degree to look at the following and think, gosh, that seems pretty bad. We had President Donald J. Trump repeatedly reference the term fight in his address to the crowd on the early afternoon hours of January 6th, referencing or urging them to march or go down to the Capitol and telling them, you'll never take back your country with weakness. You have to show strength. You have to be strong. His personal lawyer, Rudy Giuliani, preceded that speech by telling the crowd, let's have trial by combat. Next slide, please, Daryl. So what is insurrection? Merriam-Webster or the dictionary says it's an act or instance of revolting against civil authority or government. United States Code, the federal law on rebellion or insurrection, and I've highlighted the key terms, but it's inciting and assisting any rebellion or insurrection against the authority of the United States. So that would seem to present a fairly decent case potentially against the speakers on January 6th, including Rudy Giuliani, the president, and the president's son as well, who also referenced or addressed the crowd and others. And then to incite from US Code is to organize, promote, or encourage, participate in, carry on. And that includes, but is not limited to, urging or instigating other persons, but shall not be deemed to mean mere oral or written advocacy of ideas or expression of belief. And this is where things get a little bit complicated. Next slide. The problem is the First Amendment and freedom of speech. And the seminal United States Supreme Court case in this regard is the Brandenburg case, a late 1960s case where somebody from the Ku Klux Klan was speaking in Ohio, was prosecuted under Ohio's statute from the early part of the last century during the Red Scare, the so-called Red Scare, that criminalized certain types of speech. And a case went all the way up to the United States Supreme Court, which essentially the finding was that the holding was that the government cannot constitutionally punish abstract advocacy of force or law violation. And political speech is, of course, the most protected of our types of speech, given the protections of the First Amendment. So the way that the analyses have been shaping up, at least during the last week, is that a federal prosecution against the president, against his son, against Rudy Giuliani, would run into the First Amendment and political speech, and it may make things difficult. Now, I'm not the only person who thinks that, and I'll quote a few people. There's an unnamed source from the Justice Department, and I think from reading the full version of this that it's somebody from the Justice Department in DC, but I can't tell with certainty. But the quote from the current Justice Department official is, encouragement can cause criminal liability, but it's got to be more than a politician making reckless comments to their base, especially because a politician's blustery or incendiary comments are still protected by the First Amendment, the official said, speaking on condition of anonymity. Jordan Strauss, who served in the Justice Department for President Obama, for the Obama administration, said, it would be hard to bring a criminal prosecution. According to federal law, people can face rebellion or insurrection charges for offering aid or comfort to rioters. So a broad reading of sedition and insurrection laws could theoretically allow for prosecution of senior officials, but the legal issues would be thorny related to the First Amendment, said Mr. Strauss. Now, that is the case, kind of, so to speak, against prosecuting the people at the head. It's not an open and shut question. This is not mathematics, this is the law. And so we apply the facts to the law, and various prosecutors and defenders see things differently. That's routine. it's important to keep in mind that there's a legal or criminal law prosecution question, and there's a political question as it relates to inciting insurrection. The political question relates to impeachment, which Professor Fallon is going to speak to. Next slide. So what about these guys and the other folks? Everyone from the QAnon shaman to the people climbing the walls of our Capitol to the West Virginia legislator who in the Rebels sweatshirt was pulled off in handcuffs the other day for his involvement, broadcasting himself from inside our nation's Capitol, and the special gentleman who had a seat at Speaker Pelosi's desk and decided to take a piece of her mail and or possibly other items. These are, next slide, what we would call in the law people who committed substantive or people that are doing real federal crimes as opposed to soliciting or encouraging others to committing those crimes. Now we saw the first wave of arrests made and the first indictments filed, and most of them involved kind of what I would characterize as lower end federal crimes, not unserious, but lower end. Things like knowingly entering or remaining in restricted buildings or grounds without lawful authority, theft of government property. Later last week, through the weekend and into this week so far, the investigation has revealed further evidence that is troubling and disturbing, revealing assaults of law enforcement officers, revealing attacks that are more violent than those things that were first captured when we were all watching the news of last week, Wednesday. And this is what happens in investigations. Oftentimes prosecutors file placeholder, if you will, charges. They issue arrests and they have the authority, generally speaking, to file superseding indictments or additional criminal charges as evidence becomes developed. And in this case, there are quite a few law enforcement officers now backtracking and trying to ascertain the involvement of people that were at the Capitol, that were captured on film, and that largely, unfortunately, because of the lack of preparation by law enforcement to prevent or repel this attack on the Capitol, were allowed to leave for the most part and to be caught up with later. And so that's the endeavor now. And so as the investigation moves forward, are we going to see more serious charges like seditious conspiracy or homicide-related charges, or charges such as assaulting a federal law enforcement officer, or aiding and abetting crimes like manslaughter for the poor gentleman that lost his life, or felony murder is another option. And the law, generally speaking, allows aiding and abetting to be prosecuted as fully as the person who committed the substantive crime. And so that's another consideration, and it's early yet to say what types of felonious charges will be filed against the people doing the things inside of the Capitol, the substantive crimes. But this is a broad overview of what I expect you will see forthcoming in the weeks and months after January 6th. Next slide. There's a few other criminal justice considerations. We've seen a lot of whataboutism. One of the first whataboutisms was, well, what about the Black Lives Matter movement, as if that were, as if a small amount of violence related to the largely peaceful protests were urged and encouraged by, for example, Vice President Biden at the time, which they were not, and which were disavowed by everybody on the, so to speak, other side of the political aisle at the leadership level. So the whataboutism is false. But people have also said, well, what about this? What about law enforcement related to protecting the Capitol during the Black Lives Matter movement versus protecting the Capitol or related monuments during the events of last week? And so these are questions that are legitimately being asked. At a very base level, the duty of the Capitol Police, for example, is to protect and ensure the safety of the people fulfilling the functions of government. That was a failure, and it's fair to ask why that happened and whether the prevention of law violations, the prevention of crime, is enforced equally in our society. Next slide. Investigation methods will continue involving digital data to a high degree because a lot of Video is available from the Capitol events, combined with facial recognition and other even third-party or non-governmental organization assistance. Next slide. And I've had a thought as I've moved forward, and when I think about general criminal law topics, about the concept of general deterrence. I've stood with clients many times in front of judges and listened to prosecutors make arguments and judges impose sentences where general deterrence arguments are made. In other words, we need to, so to speak, throw the book at you in order to keep you from doing this again, but more importantly, to show the public that this won't be tolerated and that you're really going to pay if you commit a crime like that. I've been a doubtful subscriber to the concept of the utility of general deterrence, generally speaking. I don't necessarily think the decision to commit a crime works quite that way. But having sat in front of benches for those arguments as they're made at nonviolent drug offenders often and responded to with large amounts of incarceration, it has occurred to me that if ever there was a time to pay credence to the concept of general deterrence, a very, very public crime against the basic democratic institutions of our country, carried out by those who have other proponents nationwide as a result of this fraud that's been committed about election fraud, this baseless lie that Ms. Jacobs took us through. This may be the time for general deterrence for those found guilty of crimes committed at the Capitol. Next slide, please. Lastly, I just want to close with this. The criminal law and prosecution of criminal law is largely carried out across our country with almost voluntary participation, even of the people prosecuted. In other words, people are summoned to court, they are arrested and released, and they come back to court. And we invest as a society in the basic premise of the fairness of our system. And what makes racial inequities and disparate treatment of racial minorities in the criminal justice system, or disparate violence against people of color as reflected in the Black Lives Matter movement, what results is a lack of trust or a shaking of that foundation. And the events of the Capitol and how they move forward and are treated by the institutions of government, our prosecutors' offices, our courts, are an opportunity to either add to that general trust and promote the public's thinking that we have a fair and just system, or an opportunity to lose that if they aren't handled with equitable rigor and perseverance with regard to the people rioting and participating in a carrying out of an assault against our Capitol, as much as they are for routine law violations across the country. And so that opportunity is there, and how it plays out remains to be seen. Thank you.
Wonderful. Greg, thank you very much for that well thought out and articulation of what we're looking at here. So much goes into all of this. And once again, we hear so much rhetoric being placed out there that is absent any place in fact or with reason, given a lot of the recent comments made by the President's attorney, Rudy Giuliani. So thank you for articulating that. Next, we want to turn it over to the Associate Professor of Marquette University Law School, who instructs on constitutional law, amongst other things, Professor Ed Fallon. Ed, thank you so much for joining us this evening and helping to bring that constitutional context to the issues that are just so profound to the future of our democracy. Thank you for joining us.
Thank you, Daryl. Thank you to my distinguished co-panelists for their insights, and as the third person on the panel for sticking to the schedule. I want to thank Forward Latino. I want to welcome everyone watching. Bienvenidos a todos. Really, my job here is to talk about two things. First of all, the electoral certification process. What was going on in Congress on January 6th? And what were the constitutional and statutory rules that govern that process? And then secondly, the impeachment process that now is underway once again. Donald Trump now could very well by Wednesday be the first president to ever be impeached twice in their term in office. So let me turn first to the electoral certification process and some background and some context for what was going on there. And I think the process is very straightforward. I mean, we've for over 200 years, we've had peaceful transitions of power. Everyone knows that we do not have a direct democracy in the United States. Instead, the voters cast their ballots and are actually electing members of the Electoral College from each state, who then convene and cast their votes. It's indirect democracy. And that the individual who receives in the present day more than 270 electoral votes then becomes the next president of the United States. So what was different about this year and January 6th and this process? Overall, I think there are two big picture things to keep in mind. First of all, what we've been seeing from the Trump administration reminds me of a NFL football game where time has run out, but one team is behind and they have the football and they are trying desperately to keep the play alive. And they are doing laterals and they are intentionally fumbling the ball and kicking it, anything to keep the play going out of some hope that a miracle might happen. Because if the final whistle blows, it's all over. And I think that that is really what the Trump administration has been doing. It's just anything possible to keep the process alive and uncertain and not concede, because they hoped that something would happen. And the second big picture thing to keep in mind is something that I've talked about a great deal, and this is the conservative legal movement that's grown in the United States, which doesn't care if you've got a law that's been understood for over a century, or in some cases over 2 centuries. And everyone knows what the words mean, and it's been understood to mean a certain thing for 200 years. They want to take the words and they want to argue, you know what? Everyone's been wrong for 200 years. I can manipulate the words. I can stretch the words. I can take the words out of context. And I know the real meaning, and it's completely different. And here again, something as simple and straightforward as the electoral process is suddenly subjected to these reimaginings, reinterpretations, and things we've understood for hundreds of years, we're told, we're supposed to believe, we've all been wrong for centuries. And of course, that's not true. They're simply manipulating the words to try and get to some result where Trump can declare victory. So the electoral vote certification process. The United States Constitution has the 12th Amendment. And it provides that on a date certain in January, the electoral votes are transmitted to Congress, and they are opened and counted under the supervision of the President of the Senate, the sitting Vice President, and that the person who receives the most electoral votes is elected President of the United States. The 12th Amendment was added to the Constitution because initially the Constitution did not have this process. It was simply stated that whoever received the most electoral votes for president was president, and the runner-up became vice president. We didn't have political parties. It was assumed that you would have distinguished individuals, unaffiliated with any party, and you would just have whoever got the most votes and whoever got second place. Until we got to the election of 1800, when Thomas Jefferson and Aaron Burr tied. They were ostensibly in the same political party, but it was the first creation of political parties. And it was discovered that, you know, everyone on the Democrat Party agreed Jefferson was supposed to get the most electoral votes, but Burr ended up getting the same number, and we had a crisis. And so we got the 12th Amendment, which now provides for separate votes for president and vice president, and the transmission of those votes to Congress, and a reading of the votes, and official declaration of who's the winner. It was simply a response to that election of 1800 and change to the Constitution. And so that's why we have the process the way we do. It is intended to be completely ministerial. It is just pro forma a ceremonial process. But we also have a federal statute called the Electoral Count Act. It's located in Title III of the United States Code. And that law was passed following another disputed presidential election, the presidential election of 1876, when historians agree Rutherford B. Hayes pretty much stole the election away from Samuel Tilden, who had received more votes and should have been elected. And what happened was that we had 3 states in particular at that time who submitted dueling slates of electoral votes. And it was unclear when it came time for Congress to count the votes, which slate from these states they should accept and which slate they should reject. And so Congress ended up creating a commission to figure out what to do. And the commission threw the election to Rutherford B. Hayes. And we can get more into that, but you're not here for a history lesson. But the response was that Congress said, we can't have this because it's not the job of Congress to get their hands dirty in deciding who gets the Electoral College votes. And so there is a provision for objection if there are competing slates of electoral votes that are certified from a state. Then, yes, then Congress is given a role under the law to decide which of these 2 competing slates to accept and which to reject. Now, everyone watching will say, hold on. There was not a single state out of 50 that sent competing electoral votes to Congress. Every state in this last election certified 1 set of electoral votes, and it was official. And yet, and here's where the stretching of the words comes in, the congressional objectors and the defenders of President Trump argued that Congress on its own, even without a competing slate, could reject electoral votes and decide not to count them. There is no support for that in the Electoral Count Act, passed in 1877. It's never been understood to give Congress that power. There's no support for that in the 12th Amendment of the Constitution. That's never been understood to give Congress that power. It's always been understood in our country that states run elections. And if there's a challenge to the voting in a state, that it was improper, that it was fraudulent, right, as Ann Jacobs talked about, it is to be decided under state law through lawsuits in the courts or by state legislatures passing a law deciding, you know, this election was a failure, we're going to have to redo it or whatever. But the remedy is the state to fix the problem. And it's very clear if you go through the Electoral Count Act that that is the idea. The states get to decide who receives the electoral votes from their state. And all Congress can do is count them unless there are competing slates from a state. And then Congress decides. But we didn't have that. So by any precedent, understanding, history, what President Trump and the objectors in Congress tried to do was absolutely not supported by the law. Why? What were they trying to accomplish? Well, I think they were simply trying to hope that there would be sufficient support in Congress to go along and vote to reject enough electoral votes from enough states to bring Joe Biden's total below 270. And then they could claim, now what do we do? No one has 270 electoral college votes. Still, the House of Representatives, if that's the case, is supposed to vote and decide. But if you've got unrest, protests, armed people in the streets, even if they have no justification, even if it is bogus, the threat, the intimidation would create uncertainty and maybe a very scared Congress. Politicians are not known for being very brave. A very scared Congress might say, oh, even though Biden still got more electoral votes. We're going to create a commission. We throw up our hands. We don't want to put our necks on the line. I think that was the hope after all this kicking the ball around and delaying, and then inciting people to go march on Congress, trying to ramp up pressure. We are very fortunate that it failed. It was such a long shot. It deserved to fail. And so what are the consequences? We have impeachment. And of course, I'm going to be the panelist who goes over time. It's almost February 2nd, so of course it's almost Groundhog Day, so we should relive the Trump impeachment process. I would say at the outset, impeachment is, in my opinion, a political act. A lot of commentators and law professors sometimes get very legalistic about impeachment. In my view, it's a political act. It is one branch of government exercising its authority to remove the head of another branch. And don't tell me about what can and can't happen. If they want to do it, they do it. The process, as you may recall from just under a year ago, is the House of Representatives approves articles of impeachment by a simple majority. And it looks like there are enough votes to approve such articles against Donald Trump for at least one count of inciting insurrection against the United States. Then that article must be received by the Senate, and they must hold a trial. It may be very short, as we saw last time Trump was impeached. It may be pro forma, but they cannot ignore it. And there is required a 2/3 vote of the Senate, a supermajority, to convict. And beyond that, there's sometimes talk about it has to be a proper subject matter. And we saw a year ago that it was the Ukrainian phone call that was the substantive grounds of the impeachment count, really the main one. There was also obstruction of Congress, but it was the Ukrainian phone call because that was bribery. And impeachment is reserved for high crimes and misdemeanors and treason. And sometimes you get legalistic arguments, well, it has to be a high crime and misdemeanor, only certain crimes. And bribery and the Ukrainian phone call certainly qualified. And I think that's why that was the main grounds a year ago. Well, if high crimes and misdemeanors against the United States means anything, it means a politician, a federal official, taking an action threatening the government of the United States. And so I think insurrection and inspiring insurrection, inciting insurrection, clearly meets the subject matter of possible grounds for impeachment. Now, unfortunately, there is no time. The Senate is not in session until January 19th. And under the Senate rules, in order for them to convene earlier, they would have to follow unanimous consent. Every single United States senator would have to vote in favor of convening earlier in order to start a trial before Inauguration Day. And that's not going to happen. That is just not going to happen. And so therefore, really either a Senate trial could begin contemporaneous with the start of the Biden administration, or it could take place somewhat later. And there have been some calls for the House to approve articles of impeachment and delay about a month or 2 months before transmitting it to the Senate. Some of you listening will say, well, Trump will be gone. What's the point? There is precedent that you can impeach an office holder even after they've left office. And so I don't think that that would be a concern. You might see the Trump folks try to challenge that, try to bring a lawsuit, go to the United States Supreme Court, challenge that. It's never been ruled on by the United States Supreme Court. I doubt they would get into it this time. They would be wise to stay away from it. Again, this is a political process, not a legal one. But I certainly think it's possible to convict Trump by a 2/3 vote, even after he's left office. And what's the point? Well, the point is this. There are 2 penalties for impeachment. One is removal from office, but the second is being disqualified from ever holding federal office again. And here it's interesting. There is actually a possibility that there are Republicans maybe personally ambitious Republicans, who would be very happy not to have Donald Trump on the Republican ticket in 2024. And so you might actually pick up Republican support more for disqualification of future office from removal of current office. And I think that that is what Speaker Pelosi and the Democrats are counting on. You still would need 2/3 vote in the Senate. That is still a steep hill to climb. And I'm not sure you could get to there. But it would certainly, again, as a political process, force Republicans in Congress, in the Senate, to go on record, either supporting the actions of President Trump and what happened on January 6th as normal, commonplace, nothing to be concerned about, or else condemning it, which I think every rational citizen in the United States has done. So I see I've gone over by a couple minutes, but I warned you I would. So thank you again, and I hope that there's still some time for some questions from our listeners.
Wonderful. Thank you so much for that, Professor Fallon. Being able to once again put it into the constitutional context for us is really important. Being that we are out of time, we're going to ask everybody, if you have questions that we haven't already answered, please go ahead and put them in the comment section on the Facebook page, and we'll consult with our panel of experts, and we'll try to get some answers out to you in the next couple of days. But once again, we did all this evening. We brought together all this expertise to share with you the facts. The facts with regards to the election, the facts with regards to election and constitutional law, and the potential processes moving forward. And we did so not only you were aware of the facts, but so that you could advocate for our nation, for our Constitution, for our democracy, that you'll pick up the phone and you'll call both your senators and your representative, no matter what state you're in, and share with them your displeasure over the current state of our nation, and that you insist that they be transparent and honest and follow the real law, follow the real facts, and not let them get away with so many of these disingenuous statements that we saw even uttered again after the violent attack take place on the Senate floor. So once again, if you call 202-226-8000, that's the general line for the U.S. Capitol. You can ask them to connect you with your senator, and then call back again, be connected with your other senator and your representative. And it doesn't matter if they're Republican or Democrat. It's important that all of your elected representatives, they hear from you. So they know, for the ones advocating for it, that they have your support. And for those who aren't, that they feel the pressure to need to do so. So if you have any other questions, please feel free to email us at update@forwardlatino.org. We will also be placing periodic updates at www.forwardlatino.org. Once again, a tremendous thank you to all of our distinguished panelists. Big virtual round of applause to all of you for taking time out, especially on such short notice, to really cover such an important issue during a time which, like I'm sure all of you, like me, never imagined could have happened here in the United States. So thank you all once again. God bless all of you. God bless our panelists, and God bless the United States of America. Good evening, everyone.